The Nigerian Financial Intelligence Unit, NFIU, has released a guideline to reduce vulnerabilities created by cash withdrawals from local government funds throughout the country. The guideline, amongst other things, seeks to systematically restore local government areas' financial autonomy. Now, since its release, the guideline has generated controversy among lawyers and other stakeholders over its constitutionality. Now, joining me to speak more on this is a legal practitioner, Ayo Ademiluyi. Good to have you on the news. Well, it looks like the question of constitutionality or otherwise may render NFIU's directive ineffective.
Well, the reality is that the funds of local governments are generally disbursed by state governments. And what has practically turned out is the fact that most local governments across the country have been paralyzed by that, purported disbursement of funds, which are most times appropriated by most state governments. Now, despite the intendments of the NFIU guidelines, the reality is that the provisions of the Constitution of Federal Republic of Nigeria, 1999, as amended, limits the powers of the NFIU in regulating disbursement of funds by state governments to local governments. Section 162, Section 7 and Section 8 of the Constitution only prescribes that state governments have that constitutional power to disburse those funds to local governments. What that means is that for us to have what the NFIU guidelines want to bring in place, we need a fundamental amendment of those provisions of the Constitution. Because in any event, we are still in that situation where most local governments will still be paralyzed under the powers of disbursement by state government.
So in other words, what the governors are saying is they are constitutionally backed to supervise, disbursement of funds to the local governments.
Very well. Yeah,
okay. All right. Now let's even look at the revenue sharing formula, which has always been a subject of debate over time. The federal government gets 52.68%. Governors get 26.72%, while the local government, all 774 of them, about 20.6%. Isn't that where the debate really should start from?
Very well. The reality is that ordinarily local government is the closest level of government to the working people. Ordinarily, it should be the most functional level of government that can be able to attend to immediate needs of the people. But quite unfortunately, the reverse is the case in Nigeria. I've said, despite the constitutionality of that provision, that Section 162, Section 7 and Section 8, the overwhelming reality which the NFIU guideline want to help, but unfortunately it is limited and it is ultra-virus of the Constitution, is to make the local governments to be autonomous. And then to answer your question directly, of course, there should be direct funding for local government. But now you don't have to now weigh the other scenario, which is that other scenario is the fact that most of the local governments are not even elected councils. I mean, most local governments are run by caretaker committees, which are put in place by governors of most states. So the major issue about democratizing local governments is first and foremost the question of elections.
All right, let's even look at what the NFIU is saying, the reason why they want autonomy, financial autonomy for the LGs. The issue of corruption and graft at the state level. Let's assume that, constitution or no constitution, morally, would you even say that truly, if the LGAs do get financial autonomy, that it will put an end to corruption?
I've said no. That no is the answer, because fundamentally what genders corruption is the fact that even across board is the fact that there's limited democratic running of structures of the state. The fragments of society don't have direct input into day-to-day decision-making of state affairs. So fundamentally, that's what we need. But at the same time, it's also a step, no matter how limited the results may be, in the right direction. If we have local governments autonomously running their finances on their own. So in any event, the reality is that the Section 3 and Section 4 of the NFIU Act 2018 empowers the NFIU to monitor and analyze and give information to law enforcement agencies as to questions of money laundering and all that.
Well,
it can also extend its power in respect of that. If you realize the guidelines talks about the question of monitoring financial institutions, it can equally activate its powers in that regard.
Well, the NFIU says it will deal with defaulting individuals or firms that actually abet diversion of funds.
Yes.
Whether it has a power to do that.
It must also avert itself to the provisions of the Money Laundering Repeal and Enactment Act, which was just passed by National Assembly less than 2 days ago.
All right. We'll have to leave it there.
Very well, sir.
Ayo Ademiluyi is a lawyer. Thank you very much for joining us on the news.